Yo, what's up, ladies and gentlemen? It's your boy Teflon from Paid the Cost Podcast. Also often, we tend to forget that, there's laws with everything that we do, and even, carrying this, concealed weapons, there's ways to legally carry these things, because we're in a state where we're able to legally carry these things. So, now it's time to educate you on, the things that you can and you can't do when exercising your rights as far as legally carrying. Also often, we tend to not, we tend to overlook, the rules, because there's rules to everything. There's a yin and yang to everything. We tend to overlook those things. So right now we're gonna listen to um actually I don't know his name, but you know he's an expert as far as these CPL laws. So we're just gonna try to educate ourselves on this a little bit. Push that like and that subscribe button for more content. Pick up what I'm talking about. Your boy Teflon Don, Paid the Cost Podcast. Let's get it. CPL license, the laws. I don't know where the fuck my damn volume at.
To a collision. But regardless, what happens is these two guys are in this parking lot. They start arguing, right? And there's nothing really going on. They should have just left. Nobody needs that kind of drama in their life. But instead of taking a deep breath and just leaving and getting out of there because public confrontations aren't worth it, he lifts up his shirt. He's got his pistol in his waistband, and he's like, "You want some of this?" And thinking that basically showing a gun is going to diffuse the situation, and it doesn't. What happens next? Well, the other guy does get scared, runs into his vehicle, runs up, runs away a little bit, calls the police. This guy's flashing a gun. This guy's flashing a gun. Meanwhile, there's a third party witness, not, I don't know, probably 2, 3 parking spots away, who doesn't know anything of what's going on, knows nothing of the confrontation or who really started this confrontation between these two guys in the parking lot. All she knows is that she's got her kid, and they watch the guy lift their shirt and have a big old gun right there. So now you got a situation where multiple people saw a guy just lift his shirt, show a gun in an attempt to, what seems like intimidate him. And this guy was charged with brandishing. Quite frankly, I don't know all the details of the case, but the details that were put on the record that I was able to observe is, there were a lot of the elements for brandishing that were met in this situation. The guy should have never done it. And so what happens, because he has to enter this plea, that bars him from carrying a gun concealed legally in the state of Michigan for 8 years. That's an 8-year CPL loss. 8 years without rights over an argument that never had to happen.
Right.
That was between some other Yahoo in a parking lot and this defendant here, who has zero criminal record. That was stated multiple times on the record. He has got no previous criminal history. Now has to sort of suffer the consequences and, quite frankly, be a little less safe because of this lapse in judgment. And it's important that folks go back and revisit, their training on what the purpose of having a CPL really is in the state of Michigan and what self-defense really is.
Right.
And there's probably a lot of argument and debate over that. I'm a pretty big Second Amendment guy, and I'm pro self-defense. But there are proper ways to handle yourselves in that situation, and there are not proper ways. And anytime that you can take a deep breath and get away from that situation, distance, as opposed to engaging and trying to threaten, the better off that you're going to be. And it's not just about brandishing. There are really 5 main crimes that law-abiding citizens get charged with all the time that we see that interfere with their CPL rights. And if you don't hire an attorney that knows what those things are and knows the intricacies and the possibilities of potentially getting either dismissals, reductions, or winning at trial, you're going to be vulnerable potentially to these things. These are weird situations that they don't occur every single day, but when they do, they can really put you at a severe disadvantage and have a lot more impact than just being charged with a 90-day misdemeanor, a 93-day misdemeanor. You can really lose your ability to legally protect yourself out in public. And so that's what we're going to talk about today, so that hopefully
people who watch this video or who we interact with here at our office don't find themselves in this kind of situation. Hi, folks. I'm criminal defense attorney Keith Stickley with the Stickley Law Firm located here in downtown Hillsdale, Michigan. I try to make legal content for real, everyday people who find themselves on the wrong side of the law and distill it into plain English so they can better understand what it is that they or somebody that they care about may be going through. It's important to note that this video is not a substitute for real legal advice. I'm just trying to distill down what are sometimes seen as really complex legal topics into easy to understand plain English terms so that you or somebody you care about has a better shot at an offense if you ever find yourself on the wrong side of the law.
You know, a lot of times, you know, we actually really got to really educate ourselves on the laws that the land, so to speak. When I say law of the land, you know what I mean? That's the law that's made up in this community, you know what I mean, for us to be able to obtain a valid CPL, you know, CPL license, you know, and things like that. That constitute you being able to either just one second. Trying to turn this thing over. How do you flip this thing though? Y'all gotta excuse me for a second. I apologize for the delay. You know, I'm having technical difficulties because I'm trying to turn this thing around, but I guess, you know, we're not gonna be able to have that. But like I said, you know, we're gonna go ahead and continue with the content. You know, but like I said, you know, we're gonna be able to further this conversation, you know what I mean, once I give y'all a little more insight about these laws, because I actually don't know them myself, you know what I mean, I'm kind of learning them myself too, so, you know what I mean, you know, we sitting here learning this stuff together, you know what I'm saying, so pick up what I'm putting down. Teflon Down, Paid to Cost Podcast. Come on now.
Trouble here in the state of Michigan, give my office a call, 248-246-0607. We'll either bring you into our office or we'll have a phone consultation and see how we might be able to help you. And if you're just having fun and you're enjoying the channel and you want to show some support, feel free to check out one of these really neat get out of jail card t-shirts featuring yours truly. There's a link to all of our merch here in the comments below on the video. Now back to your regularly scheduled content. So here in Southwest Michigan, we have tons of CPL holders, concealed pistol license holders. And it's important to note that concealed pistol license holders tend to be some of the most law-abiding citizens in the state, and the crime statistics show that time and time again. The overwhelming majority of all CPL holders will never have any negative contact with law enforcement in their entire life. That being said, CPL holders do run a real risk of making simple mistakes that can have massive consequences and their ability to legally carry a concealed firearm. And some of the cases that can trigger these consequences are shockingly common. It can occur from a routine traffic stop or even by receiving a ticket for being a disorderly person after an argument at the local pub. So stick around here and I'm going to walk you through the 5 biggest ways that I see law-abiding people lose their CPL, and we're going to address what they can do about it. So jumping into this, we're going to talk about the 5 main things that I see people running afoul of the law and potentially losing their CPL over. Number 1 is alcohol, and the 2 different ways that having alcohol and a CPL can bite you. Number 2 is pistol-free zones. Number 3 is a failure to disclose at a traffic stop or some sort of police contact. Number 4 is probably the most overcharged crime that we see in this category, and that is that of brandishing. And last but certainly not least, number 5, simple misdemeanors. And I'm talking about misdemeanors like being a disorderly person and domestic violence. And quite frankly, how domestic violence 76948 deferrals can potentially save your CPL in the right case if you're charged with domestic violence in Michigan. So let's jump into the first sort of landmine, if you will, that often gets people with CPLs in trouble, and that is having some amount of alcohol on board in your system. So it's probably a no-brainer that people who are under the influence of alcohol should not be carrying guns. I think we can pretty much all relate to that and understand that, right? It's a no-brainer. But we need to talk about what really happens, because mistakes do happen, and quite frankly, those mistakes can have some pretty serious consequences. So let's just talk about the stereotypical situation that we've had, and I've had dozens of these come in, and that is if you're simply carrying somehow, oftentimes in some sort of either a public place or maybe even in your vehicle, but you're not intoxicated. Michigan has set some pretty specific blood alcohol content tiers if you're carrying concealed. Now, if your BAC, your blood alcohol content, is between 0.02 and 0.07, you could potentially be charged with a civil infraction, and your CPL is suspended for a year. Now, what does that mean? What is a civil infraction? Well, a civil infraction.
I say that's important because, you know, I mean, you know, we got a lot of people, you know, I mean, that tend to be, you know, full of alcohol and things a lot. You know, so a lot of times, you know, you may be legally able to carry this thing, but you know, I mean, you're not legally able to do what you protect yourself when you got alcohol in your system and things. You know, so once you sit back up in court, it's a whole new direction that this whole thing may go when you got alcohol and you violating these different laws as far as, you know, the CPL laws, so to speak. So I guess, you know, I mean, we're just really educating ourselves on this. So why don't you just pick up what I'm putting down?
Breaking the rules or the guidelines, but it's not technically a criminal act. It's not a criminal act. You can't go to jail for it. Civil infractions are only punishable by a fine or some other condition that certainly wouldn't include
any amount of jail time. And so that's what we have here. If you're between 0.02 and 0.07, then you have to pay a $100 fine. Now, sometimes there's some court fees and costs that go along with that. But most importantly, in relation to this video that we're talking about, your CPL will be suspended for a full year. Now, let's talk about having a BAC a little bit higher, a BAC of 0.08. Now, 0.08 is now also the legal limit for operating a vehicle under the influence of alcohol. 0.08 all the way to 0.099 is a misdemeanor level under the CPL statute of Michigan, and that will give you a court-ordered 3-year suspension of your CPL privileges. And most importantly, a BAC of 0.10 or you're under the influence, your CPL is going to get revoked. And it said that refusing a chemical test could also potentially trigger a 6-month suspension. Now, if you're wondering exactly what that means by a 6-month suspension of your CPL rights if you refuse a chemical test, you might want to refer back to some of our OWI videos that we posted here on this channel. A chemical test is not the roadside PBT test that officers might have to have you blow into if they suspect that you're drinking and driving. A chemical test is actually a specialized machine that will either be housed at the jail or a chemical test is a blood draw to accurately determine your blood alcohol content. So if you're carrying and you refuse to submit to that test, that will result in an automatic 6-month suspension of your CPL.
Now, that's important because, you know, actually I really don't know this one right here, but I want to educate myself on it. Now, so that means marijuana may become a factor in this right here now, as far as when they have, you know, as far as like things in your system. And it's crazy that, you know, marijuana is legal, you know, alcohol is legal. So, you know, it's going to be, you know, these laws is going to be really kind of like touchy and, you know, kind of like iffy, you know, so you're going to have to really learn them. So if you're able to, you know, legally obtain, you know, a pistol, you're gonna have to start learning these laws, man, because you know they looking for every reason, you know what I mean, to take these, you know, take the ability for us to bear arms out of our hands. So because legally they're trying to strip us from that. So I actually believe there's going to be a race war. So you know what I mean. But that's for another story. But you know let's first get into this. The CPL holders.
All right. And that kind of all leads into what happens if you have a CPL, but then suddenly you're charged with drunk driving and you end up with an OWI conviction. So there's a couple separate things that add into this equation that you really need to know about. And this is why you don't want to get any
near a drunk driving charge while having a gun on you, okay? Even if you weren't carrying, quite frankly, a lot of these rules take place. So if you have a first offense OWI or operating while visually impaired, either one, you are ineligible for having a CPL, for getting a CPL for 3 years. And if you have a second offense OWI, then you are not eligible for a CPL for 8 years. It's an 8-year suspension. Now, if you already have a CPL and you become ineligible because of a conviction, in other words, you have a CPL, but you get pulled over, you have the OWI, the county clerk will suspend or revoke after being notified of the change in eligibility. So a lot of our clients who have CPLs who end up getting a conviction for an OWI, sometimes they're a little bit surprised. And we try to warn them up front. You might be getting a nastygram from the county clerk demanding you to turn in your CPL, and you're going to have to comply if that in fact is the case. So how in the world do we defend or mitigate those circumstances if you find yourself in this situation making this terrible mistake? And quite frankly, it's not always an easy predicament to be in. But we work really, really hard to avoid CPL listed convictions. You see, the state of Michigan has a really long list of certain charges that put you in these categories that result in CPL suspensions. And it's important that you work with legal counsel who knows that list and knows what alternatives might be if you're entering into some sort of a plea deal. The other option is, quite frankly, you might not be guilty of what they accuse you of. And that happens a lot. Right. And if that's the case, you better retain an attorney who's willing to go all the way into a trial. And we do that here when we need to. Just because you're charged with this does not mean that your rights are going to go away. If you have to take these kind of cases to a trial, you can win, and if you win, you do not lose your rights. There's one little caveat to that, though, that I try to explain, and this can be a really tough pill for a law-abiding citizen to understand, especially if they think that they've been accused improperly. And that is, while you're on bond, that sort of middle, that's not really even a middle ground, but that court supervised time between when you're charged with a crime and when you're either convicted or that crime is dismissed. You're on bond. You're sort of like liable to the court, right? A lot of times you have to check in with the court during that time. When you're on bond, you are not going to be able to exercise your CPL privileges. Yes, you're still considered innocent, but the court can impose restrictions, and they almost always impose restrictions on possessing a firearm. The second trap, as we'll call it, that often gets law-abiding people on the wrong side of the law in regards to CPLs is carrying in a pistol-free zone. You see, just walking into the wrong type of establishment while you have a gun on you can create problems if you're found out, if you're caught. And if you're charged, those CPL sanctions can escalate pretty darn fast.
So it's kind of like telling us, like, even though, you know what I mean, you may have a CPL, license, and be able to hold and carry, you can't go everywhere. You got to know where actually you got to actually know where you can or where you can't go. Some places is not warranted, pistols cannot be there, or you will be sanctioned, and you will actually, you will get, I guess what they call it, a citation first, but then that turns to fines. But I don't think that it will be able to turn to jail time, not at all, unless you do some things with it maliciously, being drunk or having something in your system. So now they're talking about the different places that you can and you can't go, to hold these things. So actually, I really didn't know that either. But I know there's certain places you can and you can't go, but I never knew that was kind of like documented.
Civil infraction, again, a fine up to $500, and they will suspend your CPL for 6 months for doing that. Now, if you get caught a second time, pretty much any time in your life, they're going to charge you with a misdemeanor, and the fines are going to be up to $1,000, and your CPL is going to be revoked. They're going to straight up just take it away. A third offense for carrying in a pistol-free zone is going to be a 4-year felony. It's pretty serious, up to a $5,000 fine, and of course, they will again revoke your CPL. Now, there are a ton of locations that are deemed pistol-free zones that you are not allowed to carry in. So before you go out in public, it would really be beneficial to you to review that. If you're going to some area that you're not familiar with, or some sort of a sporting venue or something, it really will be in your best benefit to go online, search Michigan pistol-free zones, make sure it's from a .gov or something that'll tell you where it is you are not allowed to carry, or ask an attorney that you trust. You know, the general rules are, and there are some exceptions to schools. I'm not going to get into all those in this video, but in general, schools are off limits, daycares are off limits, stadiums, churches, unless you are granted permission by sort of the presiding pastor or whoever leads that congregation. 2,500 seat venues, most hospitals. There's been a lot of pushback on this lately, but college dorms and classrooms, and there's some specifics there as well. But most questions that we get come about from bars and restaurants where alcohol sales by the glass are sort of the primary source of revenue and amount for the majority of the revenue. Also casinos. So, but you want to take a look into that. Now, one of the questions that I get asked all the time is, how do I know if I'm carrying in a bar or a restaurant? And I'm going to tell you right now, to the general public, that's actually a really tricky call to make sometimes. Now, one of my original instructors, in fact, one of my CPL instructors who instructed me when I was becoming a CPL instructor.
Now, this one just kind of like confused me. You know what I mean? Because some places that you go, you know what I mean? Some places that you go, and they actually have a bar in there. You know what I mean? Restaurants have a bar in there. So I actually really never knew if you could actually, if you're a CPL holder, can you go into these different restaurants that serve liquor, or are they considered bars or restaurants? You know what I mean? I really don't know. So I think that's what he's talking about now. I'm not really sure, but you know what I mean? I'm gonna learn now. Let's get it. Why the hell does keep on doing this?
And I get that. I can accept that, right? If you go down to the local watering hole where they don't really have a food menu, there is a popcorn machine on the wall, and you know, there's a couple of maybe some bar snacks or chips, you know, hanging out by the drinks, the liquor bottle
behind the bar, but there's no food on the menu whatsoever, and they're selling beer and liquor by the glass. You're in a bar. Now, where do things get kind of tricky? Well, things get kind of tricky when you're in places like, I don't know, Applebee's. I don't know why anybody would go there anyway. Ugh. But you know, TGI Fridays was a good example. You know, TGI Fridays on a Thursday night at 5:30 is got a pretty big dinner crowd in it, right? They probably aren't making most of their money through liquor sales. TGI Fridays at night, I guess I'm dating myself too, because I think most of them are closing up. But TGI Fridays after 9:30 or 10 o'clock, especially in that bar area right there, that's a completely different place. It's not even like it's the same business establishment. That's clearly a bar, right? And a lot of times they have separate delineated areas. So, you know, if you're carrying in the restaurant section at 5 o'clock and you're probably somewhat okay. I don't know how you would ever know if the majority of revenue comes from alcohol or from food at that point. But once you go into that bar area, I would say that it would be pretty tough to defend you because all bets would be off. The place looks like a bar. There's nothing but high tops as a bar. There's bartenders flinging drinks in front of you. It's probably a bar. Don't carry there. So let's talk about if you have to actually go to one of these places where you're not allowed to carry. Well, what should you do? Well, you're going to have to secure your firearm legally. You're going to have to store it somewhere and lock it up somewhere. And unless you've been living under a rock, you've probably heard that Michigan just passed recently some rather, I should call them draconian gun storage laws, safe storage laws, about how and where and to what extent you need to secure your firearm. We're going to be making a video about that rather soon so that you can get some detailed explanations on those. But if you're visiting one of these locations, prior to going in, make sure you secure your firearm legally before you enter. And if you have any legal questions, contact your attorney, do some research, and make sure that whatever way you're storing it in is proper and legal. The third biggest trap of CPL owners that they get into trouble with sometimes is failing to disclose that they are carrying to a peace officer, a police officer. And if you're carrying and you're stopped, you must immediately disclose that you're carrying. And quite frankly, show them your CPL and your state ID. Just straight up, just do it. Recently, we made a video that got a lot of traction, a lot of attention. And it's here on the channel. You can find it. And that goes into this specific element in great detail. Far more detail that we're going to get here. But just so you know, there are penalties for failure to disclose. You can get a 6-month suspension. You can get your CPL potentially revoked if you fail to do it enough. And you can also get civil infractions for it. So just a quick breakdown of this thing. If you are approached by a police officer, I don't care if it's in your vehicle or if it's out on the street, and he wants to have a direct interaction with you, calmly say, officer, I have a CPL and I'm carrying, or tell him, officer, I have a CPL, but I'm not carrying. Either way, right? Keep your hands visible and certainly don't reach for the gun or make any sort of furtive motions that could be interpreted that you're going to reach for a gun until the police officer tells you. And like I said, go ahead and review our video on getting stopped by the police when you have a gun and a CPL, because I think that you'll find that extremely helpful if you ever find yourself in this situation. And how do we fix this? Well, quite frankly, it's sometimes a little bit difficult if it's something that you just don't do, but there are defenses. And a lot of times these things can be mitigated, especially if you're polite, you're calm, and you don't do anything crazy. The fourth biggest trap, and I'll tell you, this is probably the trickiest. It really is. That is brandishing a firearm in public. The good old MCL 750-234E. Showing or displaying a firearm to intimidate is considered brandishing. Even if you never aimed a gun at somebody, pointed a gun at somebody, or intended to use it in any way. And it's a 90-day misdemeanor, and it comes with a fine as well. And the problem with brandishing is it puts you on the 8-year disqualification list. And you can't keep or you can't get a CPL during that window. So it's quite serious. Now, many brandishing cases really start as perceived self-defense displays. And a lot of...
No, I wonder if people understand that right there. What he's saying, brandishing. If we accurately speaking about what they're saying, it's like you can't even threaten the motherfucker and tell them, hey, I got a gun, motherfucker, I'll shoot your ass, blah, blah, spiel, however you roll it. You know what I mean? You cannot do that, and show it to them or whatever. That's the biggest mistake a lot of us make. You know what I mean? We brandish it, because we're able to legally carry it. But, legally that's a violation where we can lose our ability to conceal for 8 years. But I really don't know the ins and outs of it because I'm just learning it. But but I never knew that was something that you can't even pretty much do that because they should be able to see it anyway. Well, actually, no, I take that back. Concealed means it's covered up. So therefore, you can't just open your shit and be like, listen, man, get on away from me. I shoot the shit out of your ass. That's against the law pretty much. I guess they just tell you, just go ahead and protect yourself. Shoot the shit out of them.
A lot of people don't really intend to intimidate somebody when they commit this brandishing. So, we here at my firm, we push really, really hard for dismissals or reductions to non-listed offenses in the CPL suspension list so that clients don't trigger this 8-year rule with a brandishing conviction. The problem I have found in defending a lot of these cases is so often there are third-party witnesses that are separate from let's say the defendant, the person who we're usually defending, and the person that they are supposedly brandishing a weapon to. Because a lot of times these two people might be having a confrontation, right? And maybe the guy who's being charged with brandishing, or girl being charged with brandishing, really did feel threatened. But what ended up happening is by brandishing and not effectively using self-defense, if self-defense is actually warranted, is they would they scare somebody else, a third party.
There's a gun there. And suddenly the prosecutor has a third-party witness saying, well, I saw somebody flash a gun to try and scare this guy away. And that is not the purpose of a CPL. That is not the purpose of a concealed gun. The purpose of a concealed pistol on your person is to save your life or somebody with you's life. That is the purpose. It's not to scare off a bad guy. If you draw that gun, you better be drawing that gun as a tool of last resort to save your life or the life of somebody right there. And that could be a really, really hard pill for a lot of people to swallow, because they say, I wasn't really brandishing. I was in fear of my life. And, that's a tough judgment call to make. What seems as a potentially life-threatening emergency to somebody in one situation at the drop of a hat, without the time to fairly analyze what's going on, to somebody else might seem like a situation that's grossly blown out of proportion.
Now, do y'all remember that situation where the bouncer at I want to say the Wayside West? I mean, I want to say, yeah, I wonder, do y'all remember the situation with the bouncer at the Wayside West? He was a CPL, I want to say he was a registered gun holder. Got into a fight inside the bar. I guess they got on his head. I don't know the ins and outs of it, but he ran to his car. He got his gun and he shot boy. And I believe he killed him. Matter of fact, he did kill him. May he rest in peace. I want to say that was yeah. And but legally, for one, he wasn't supposed to have it at the bar. And then, for two, he did not have it on person to, when you retreat, they tell you is to keep on retreating. You're not supposed to come back to escalate the situation. So, it's kind of like crazy, but there's rules to doing the right thing in here. And you can figure that you can do the right thing because in your mind you're like, hey, man, I was protecting myself. But there's a thin line between protecting yourself and breaking the law. So we have to understand, the difference between that. Let's get it. Teflon down. Paid to Cost Podcast. Push that like and subscribe button for more content.
Add to the confusion that everybody talks about in self-defense circles today of things like the Castle Doctrine and a constitutional right to self-defense. And yes, we do have those kind of things in place, okay?
No question. And we could talk about the constitutionality of brandishing and whether or not brandishing could potentially save some lives, because quite frankly, I do believe that there are many situations where technically probably brandishing a firearm saved a potentially lethal encounter. But unfortunately, I'm not the state legislature. I don't meet those rules. I'm a criminal defense attorney who can only protect somebody within the confines that we are given. So sometimes that becomes a little bit tricky, and it's my job. Sometimes I have to go in front of a jury to try and convince them that the threat that they were responding to truly was, in fact, something to be considered life-threatening, and therefore this would not be a brandishing type situation, but a legitimate form of self-defense. I can't stress this enough. Even if you are defending life and limb, you are using that tool of last resort, you have to pull out your firearm and use it in self-defense. Just because you're justified in self-defense does not mean that there are not going to be collateral consequences, life-changing collateral consequences, outside of that single event. Yes, it's true. You might not be liable for either murder or felonious assault or some other criminal act against another person because you had to pull the trigger on the gun. That being said, if you have to pull a gun and use it in self-defense, your life will change forever. Rightly or wrongly, we can debate it all day long. The fact will remain that your life will never be the same. You are probably going to have massive civil lawsuits. You are going to have problems with your friends. You are going to have problems with your family. All this happens. We see it on a regular basis, far too regular, quite frankly. So know this. If, in fact, you need to pull a firearm for self-defense, you better make sure it is truly needed at that exact moment to protect you or your loved one's life, because everything else becomes inconsequential at this point. If you have more questions on this topic, it's vitally important that you get advice and guidance from an attorney that you can trust, that you feel comfortable with, that can truly explain beyond what they give us at the CPL course. I know that we always have a legal portion of that. But if you really do have in-depth questions, it behooves you to go out and get clarification so that everything is completely clear in your mind of what those ramifications and expectations might be before you end up taking an action that can alter the course of your life forever. And the fifth big trap that a lot of clients that we have fall into is the simple misdemeanors that they don't even perceive would have an issue on their concealed pistol license, but end up doing. And that's why if you are a CPL holder, and this is why it behooves you, probably a lot more than the average guy just walking down the street, to engage an attorney and fight and try and defend yourself in court if you're accused of one of these seemingly simple misdemeanors, because it might just be a misdemeanor. That's true. You probably won't go to jail, but the ramifications that could have on your CPL and your Second Amendment rights, quite frankly, can be massive. One of them that we see, quite frankly, is just being a disorderly person. The disorderly person charge, a lot of prosecutors really like because it seems completely minor, right? It's a thing where I don't know in years if I've seen somebody actually go to jail for being a disorderly person. In fact, the new presumption in the state of Michigan is that it's not even a jailable offense, but it's still listed as a 90-day misdemeanor. So getting a conviction for a disorderly person makes you ineligible for a CPL for 3 years. And then, of course, we have to talk about the biggie, domestic violence or domestic assault. So a conviction for domestic assault or aggravated domestic assault is on the 8-year list. What does that mean? If you are convicted of domestic violence, you will not have a CPL for the next 8 years. That's just how it is. And to add insult to injury, there are federal laws that actually basically constitute a lifetime ban if you've ever been convicted of domestic violence. Now, these aren't Michigan laws. Michigan really kind of only influences and deals with the Michigan stuff. But technically, once you've been actually convicted of domestic violence, you cannot go and buy a gun at a gun dealer if you got to go get an ATF check. When you fill out that paperwork and send it in for the background check, they will deny you. And this is very common. We see it all the time. Basically, as soon as you plead guilty to that domestic violence charge, if you have a CPL, the clerk gets notified and they send you out one of their nasty grams, as we call it, that demands that you immediately turn in your CPL, and they take it off the list, and you're no longer allowed to carry a concealed firearm. Now, some of you might have heard about a domestic violence deferral. This is really important, especially in terms of CPL holders, okay? Michigan's got this funky little law, 7694A, and I've talked about it on some videos here on our channel. You might want to go and find some of the domestic violence videos that we've made, because we do address this directly. 7694A deferrals let certain first-time domestic violence offenders or convicts get that deferral, where the court actually withholds the adjudication of guilt, and they put you on probation. And if you successfully complete that probation, the case is dismissed, like it never even happened. Why does this matter if you have a CPL? Well, I'll tell you why. Your CPL eligibility turns on whether you are convicted of a listed misdemeanor within 3 or 8 years. A successfully completed 7694A diversion ends in no conviction. It does not trigger a 3 or 8 year ineligibility window that are tied to those convictions. Now, if you're ever charged with domestic violence again, right, like a second time, you can be charged with a domestic violence second. Now, a common question that I do get asked quite often is what happens when you're on probation or bond on this deferral status? Can you carry concealed? And the short answer is almost always no. Pretty much every judge that I've practiced in front of has a bond condition that you cannot possess a firearm. And in most clerk offices, the second that they find out that you're on bond, they automatically go ahead and issue you a CPL suspension. So no, you're not going to be carrying a CPL while you're on bond or going through the deferral process. If you have any more questions about this, you're going to want to talk to an attorney you trust or give our office a call. But I have to tell you, this is one of the most important reasons why law-abiding citizens need to go and get competent legal counsel if they or somebody they care about are charged with domestic violence, because how that domestic violence case is handled can relate exactly into their Second Amendment rights.
Right.
Now, I know that's a lot to digest in one video, but the important thing to remember is if you are looking at some sort of a misdemeanor charge or a ticket or a brandishing complaint, or you're put on bond, call an attorney, a competent attorney that you feel comfortable with, that you trust before you enter into any pleas. A small tweak in the outcome, a small tweak in the strategy that you're going to use in your defense can be the difference between a 6-month or a 3-year, an 8-year suspension, or even keeping your CPI license intact. And if you or somebody you care about find yourself in this situation, by all means, feel free, reach out to my office here at the Stickley Law Firm in Hillsdale, Michigan. We're going to absolutely do our best to get you the best possible outcome considering all the situation. We're going to bring you in and we'll get on the phone, we'll do a thorough case evaluation, and we'll see where or what we can do to put you in a better situation than when you came to us. Preserving your Second Amendment rights and your right to self-defense are of paramount importance to us, and we'll do our best to fight for you and get you the best possible outcome. If you found this content helpful, do me a big favor. Like the video, subscribe to our channel, share it around with your friends, and of course, stay real safe, and we'll see you soon.
I have not seen one.
Those are things that, we got to really pay attention to. There's do's and don'ts to carrying pistols legally. And we actually gonna have to know the do's and the don'ts when it comes to carrying, this thing, legally. Because a lot of times, we misinterpret and we lead with our attitude. And if we lead with our attitude, legally, we're illegal. And it's kind of like you gotta be careful of the grounds that you walk when we out here, because the laws are designed to be against us anyway. So everything that's quote unquote a law is always a back door for them, so to speak. Because you gotta remember this: if laws wasn't broken, there wouldn't be, a lot of jobs would be lost. There wouldn't be no judges, there wouldn't be no lawyers, there wouldn't be no polices. So you gotta remember they actually want crime to happen. So you gotta actually try to prevent from doing anything that you're able to do legally, because they would try to push it, illegal. Because like I said, if we could sit back and think about, that guy, like I said again, that guy that was, he was a bouncer at Wayside West, and like I said, he was legally able to carry it, but his emotions led him to do something that he didn't want to do. So actually, he thought that he was legally doing something, but it ended up being illegal because, for one, if he would have understood the law, he would have understood that, carrying it at that bar, would have been illegal. That wouldn't constitute him to be able to brandish it there, So legally, he was illegal. And that's what I mean by that. So we got to actually educate ourselves on, what it is that we got to do and how we can, I want to say swim through these laws of through this maze, because it's set up for us, to fail. So we're gonna have to start educating ourselves on things that matters. Like I said, we gotta start educating ourselves on things that matter. Because we tend to get our mind off of real situations and tend to be in a bad place in the long run. So I say that to say this, just keep your mind open, educate yourself, and let's get it. Push that like and that subscribe button for more content. Teflon Don, Paid to Cost Podcast. Let's get it.